Ladies and gentlemen, welcome back to the IndieZoNe here on YouTube. My name is Kathy. I give my opinions here, as I always do, pursuant to the United States Constitution, First Amendment, which guarantees freedom of speech and freedom of the press regarding my pure opinions, and they are offered for educational purposes only. The question that I'm raising parenthetically, again, my opinion is, was Mr. Kohberger's due process privileges violated when an order was entered without providing him an opportunity to be heard? Now, specifically, I'm referring to the document that was signed by Judge Hippler. It is dated November 20th, 2024, but you have to look on the court docket, November 21st, 2024. It is the amended order appointing special assistant attorneys general. It does not say here that this is being provided without a hearing. That matter was raised in a filing that was dated and docketed on November 20th, where the State of Idaho requested a decision without a hearing on the state's amended petition for appointment of special assistant attorneys general. This amended order states, the above matter having come before the court upon petition of the Latah County prosecuting attorney and good cause appearing, it is hereby ordered pursuant to, and the court then gives the statutory authority, that Deputy Attorney General Jeff Nye and any other Deputy Attorney General selected by the Attorney General's office be appointed as Special Assistant Attorneys General to assist in the prosecution of this case. And again, this is dated the 20th of November and signed by Judge Hippler. The 21st of November came another item. You can see it on the docket. It is the defense's objection to this order being entered without a hearing. What Mr. Thompson was arguing is that there are local rules of court that authorized Judge Hippler to enter this order without a hearing because it was a routine matter. If you look at the defense's objection, you will see first that they are alleging that the state misread the statute, that you get the appointment of a, not multiple and certainly not unnamed assistant attorneys general to assist a county like Latah in the prosecution of a case. So what the defense is arguing is, number one, that this is an incorrect application and reading of the statute, that there were concerns that were raised because of the confidentiality of the case. Who is going to have access to the numerous documents that are filed under seal? Because no names were provided. If you look at the original petition that was filed in Latah County, you will see that the names of the two assistant attorneys general were given, Mr. Nye and Ms. Beatty, who have appeared before the court. What the defense is saying here is that there's no names that's given. You're giving an incorrect interpretation of the statute. This is not a routine matter, and we would like an opportunity to be heard. Now, although the defense has not per se raised due process, as they did in Latah County one time before, this appears to be a due process argument. It's going to turn on whether or not this was a routine matter. Now, what is due process? Due process is protected under the 14th Amendment to the United States Constitution, and it has been interpreted to mean that when the state government is seeking to take someone's property or life or liberty, that the party, whether it's a civil or a criminal case like this one is, must be provided with due process of law. And that means 1, notice, 2, opportunity to be heard. And 3, an impartial judiciary. As I noted, the defense raised due process violations back in Latah County while their later granted motion for change of venue was pending. You will recall that it was a Friday in the spring when Mr. Thompson filed a motion to stop the defense's expert witness from conducting surveys in the Latah County area in support of their motion for change of venue. That same Friday, the court entered an order stating that the case was not to be disclosed or discussed by anyone outside of those that were permitted to discuss the case in the non-dissemination order, and therefore this effectively put a stop to those surveys. That same Friday afternoon came a very terse filing by Ann Taylor on behalf of Mr. Kohberger stating that Mr. Kohberger was denied due process because this effectively, it was an injunction, was entered without an opportunity for Mr. Kohberger to be heard. So again, although the filing of November 21st does not raise the fact that specifically, is this a due process violation? It appears that that's what they are arguing between the lines. In looking at the docket, there is still no response from the state of Idaho to the defense's filing, and it is now the 6th of December. As I've stated, if you would like to look at the defense's November 21st filing, opposing them not being provided an opportunity to be heard, please go to the court docket and you can read it for yourself. We will continue to monitor the docket to look for the state's response to this motion, and we'll report back to you when it is received. And obviously, hopefully, Judge Hippler will be granting a hearing on this matter. In my opinion, I believe it's warranted. This will now conclude this episode of the IndieZoNe here on YouTube. Thank you for joining us here today.